Hello, today we've got Bill Odum with us. He is with the Odum Law Firm. His practice focuses on DUI defense law and domestic litigation. Today we're going to be talking about a procedure known as deferred prosecution or pretrial diversion. Good morning, Bill. How are you?
Great, Farrest. Good to be here.
First, just tell us a little bit more about your practice.
I'm involved primarily in DUI defense work, domestic relations litigation, and a little bit of personal injury. I started practicing law about 17 years ago, so I need in the Dothan area for DUI defense work, and so that's a large part of my practice is DUI defense work here in Southeast Alabama.
And I assume that a lot of the DUI cases are in municipal courts.
That's correct.
And tell us a little bit about deferred prosecution or pretrial diversion.
Okay, well, first of all, thank you for having me here. It's always nice to answer your questions and the questions of your listeners. Deferred prosecution, or as you mentioned, pretrial diversion, is a program that's offered in all of the municipal courts that I practice in Southeast Alabama. And what it does is it's really a free get-out-of-jail card for first-time offenders. If the offender, whether he's been cited for a speeding ticket, domestic violence, possession of marijuana, something like that, when he makes an application with the municipal court through the DA or through the DA's office, or in the municipal court, the prosecutor's office, then they'll do an investigation into his background and see if his background or if his criminal history warrants being given an opportunity to form a contract with the DA's office.
So, well, would there be something that would disqualify someone? Like if they had a criminal history, would that disqualify someone for deferred prosecution?
It would. There are certain things that disqualify him. For instance, if he has a lengthy criminal history, or if he's applying for, say, for instance, pretrial diversion in a domestic violence case, and he's already been convicted of a domestic violence case. Pretrial diversion is usually just a one-time offer to a first-time offender, or it could be an offender who has a very minimal criminal history.
And if I understand you correctly, they first have to go through the prosecutor's office and be approved by the prosecutors. Is that correct?
That's correct. They'll fill out an application, they'll sign a release, and then the prosecutor's office will turn it over to a pretrial clerk to do a background check. And depending on what they find in the background check, they may extend an offer to the first-time offender to enter the program with the prosecuting office.
Then I assume that the deferred prosecution agreement would be presented to the judge.
That's correct.
And does the judge have the discretion to accept or reject that deferred prosecution?
The judge does have the discretion. The judge also has the discretion to override a denial by the prosecutor's office for approval of the pretrial diversion program. I've had some in the past where, for instance, a military person who has been overseas found to be, when he got back pretrial, was found to be PTSD, and the prosecutor's office denied him because of substance abuse, and then because of his exemplary service in the military, the judge overrode that and granted him pretrial diversion.
Are there any downsides to pretrial diversion?
Yes, there is. Usually the cost of pretrial diversion is more than it would be if you were just to go in and enter a plea on the arrest that you're there for. But there are also many benefits to it also too. For instance, if you are concerned that for instance, a speeding ticket might affect your insurance rates, then you can go ahead and pay extra money to the pretrial diversion program because it's going to be more costly. But the advantage of that is that after a year, most of the pretrial diversion programs are 12 months. After the 12-month program, the prosecutor's office will file a motion with the court to dismiss that ticket, and that ticket doesn't come on your record, okay?
Okay, so if you successfully complete the deferred prosecution, then those charges against you are dismissed.
That's correct.
But what happens if, for example, you have a client that's out on deferred prosecution and then has another charge?
That will usually invoke a motion to be filed by the prosecutor's office to remove them from the pretrial diversion office and then program, and then it goes directly into the sentencing phase.
Because I assume if you go into the deferred prosecution, you're conditionally pleading guilty.
That is a conditional plea of guilty, you're right. And in the agreement that you're signing, it says that if you violate the terms of the pretrial agreement, then they'll revoke you off of the program and you'll immediately go into the sentencing phase of the agreement. But there's a very good reason where someone with, say, arrested for a criminal charge, say a domestic violence, or for example, a possession of marijuana second charge. Possession of marijuana second is a misdemeanor, punishable by not more than 12 months in the city jail. For instance, if you enter pretrial diversion with that and you complete the plan, and later on after the plan or after the program is completed and you have been dismissed on that arrest and you pick up another possession of marijuana second, it will not be elevated to a marijuana first, which would be a felony.
Because that previous charge was dismissed.
That's right, and that previous charge would not be considered in elevating the possession of marijuana second up to a possession of marijuana first, which is a felony.
Now, are there some limitations on the use of deferred prosecution when it comes to commercial driver license?
Yeah, someone with a CDL, a big truck driver, under federal law, they are not eligible for any type of deferred prosecution, pretrial diversion, defensive driving course, or anything like that. That's under federal law. So someone who has a CDL, and the charge cannot be reduced to a lesser included if it is. For someone with a DUI charge who has a CDL license, their alternative is to go to court and try to be found not guilty in that case, or either just figure out some way for it to be dismissed.
With a deferred prosecution, what are some of the typical conditions of deferred prosecution? Because I'm thinking, you talked about possession of marijuana, DUI. Are people on deferred prosecution typically drug tested?
They are as part of the program. Let's talk about specifically for someone who is a first-time DUI defendant. They don't have a criminal history. They've been entered into the program. To start off with, after they sign the contract with the prosecutor's office, they'll go to a CRO, which is called a court referral officer, for an evaluation, okay? And then they'll determine what level of DUI classes they have to have, 1, 2, or 3. And the cost for those 3 levels of classes are different, as is the length of time that those classes take to complete the program. So if they pick up another charge, another DUI charge, domestic violence, eluding, anything like that, that'll kick them off of the program. They're going to be drug tested during that time, and most of the pretrial diversion programs that I've been a part of are for 12 months.
And just give us an idea. Let's assume that you have a client that is approved for pretrial diversion. Let's assume that this client has a DUI. Do you have a ballpark idea of what the cost of just the deferred prosecution would be?
That differs between the municipal courts. I have seen it in some of the larger towns around here be as high as $3,700 to $4,700, whereas it could be as low as $1,000 in some of your smaller courts, okay, because the municipalities like this program because they get to keep more of the revenue, and is a benefit to the offender because at the end of the 12-month program, or in one town that I know of around here, a 6-month program, that charge is going to be dismissed and it won't appear on their MVR, which is their motor vehicle record.
And with the cost of deferred prosecution, do courts typically allow you to pay that over time?
Yes, if you're not able to pay it all up front, It has to be paid in full. They set you up on a monthly payment plan. It has to be paid in full by the end of the program, whether it's 12 months or 6 months, okay? So if it's not paid in full, then you continue on the deferred prosecution program until it is paid in full, at which time the prosecutor will file a motion to dismiss, and then you're gone. It usually costs more for the program, but the benefit is that charge that you've been arrested for, whether it's domestic violence or possession of marijuana, whatever it is, it comes off of your record at the end of the 12-month period.
And let's go back to domestic violence. Do courts typically require the offender to enroll in, say, like anger management courses?
Yes, they typically have a no contact order between the offender and the alleged victim, and then they have to take some type of domestic violence course or anger management course, something like that. When they complete it, it's based on the program that's being offered to them. The person who is teaching them or working with them on the anger management class will have to present a certificate of completion to the court as a part of having that case dismissed against the offender.
Well, Bill, I certainly appreciate you taking your time to be with us today, and that has been very informative. If somebody wants to get in touch with you, if they have a question about deferred prosecution, how can they get in touch with you?
They can call my office at 334-699-6841. We're open Monday through Friday, 8 to 5, and we close on Fridays at noon.
Again, thanks for being here.
Hey, thanks for having me. Appreciate it.